Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing chapter 4 of Indian Penal Code, which is all about general exception. In this series, this is my 7th video where I am going to discuss the provisions related to private defense. There are as many as 11 provisions which are covering private defense starting from section 96 to 106, but they are all very important and you need to know all of them in detail. That is why I am breaking them into 2 or 3 videos, and in this video I am covering the first 4 provisions starting from section 96 to 99. What I am going to do, I am going to explain with a chart all these 4 sections in the initial slide, and then I will explain what exactly Act says on these 4 provisions, and then in the last we will discuss all the case laws related to these 4 sections. I hope that way it becomes comprehensive video as far as these 4 sections are concerned, and with that commitment I am taking you to the first slide. So here is the chart where I am explaining all the 4 sections in one slide with the interrelationship that they have with each other. We have section 96 in the top, and then we have section 97 which is all in green color boxes. Then we have section 98 which is in orange color box, and then we have section 99 which is in blue color. So that way I have done the color coding also, and for each section you have to follow me along with the color code. The first section, that is section 96, defines private defense is not an offense. Now it says nothing is an offense which is done in the exercise of the right of private defense. It looks very easy. If you are doing an act for the purpose of private defense, then that cannot be considered as an offense. Now it is not that easy also. Though it looks very easy, we understand the complete meaning of this particular statement only after going through section 97 to 106. That way the last 10 sections of this particular section are supporting the statement which is made under section 96. So it becomes very essential for us to understand the other section, and let's start from section 97. Section 97 discusses about right of private defense of body and property. Now when we are saying body and property, it is not just self, it can be body or property of others also. Now we are seeing two major categories here, one the body, the other one property. As far as body is concerned, we need to know all the offenses affecting human body. Where will we understand all the offenses affecting the human body? For that, we have to go through chapter 16 of Indian Penal Code, which deals with offenses affecting human body. Few examples are like murder, hurt, grievous hurt, wrongful restraint, wrongful confinement, criminal force, assault, kidnapping, abduction, slavery, forced labor, sexual offenses, etc. can be the examples, and I have videos on all these concepts in my playlist, so you can refer there. These are covered between section 299 to 377, which is the chapter 16 of Indian Penal Code, and then comes the second part which discusses about property. When it comes to property, we have two types of property, movable property and immovable property, and if there are any offenses falling under theft, robbery, mischief or criminal trespass, then they can be considered, or the fight done for the private defense against those can be considered as an excuse under this particular section. That is what exactly discussed here. What are those? Theft, robbery, mischief and criminal trespass. And to understand this, you have to go to chapter 17 of Indian Penal Code, and I have all the videos related to this topic in my playlist. You can understand more about them by going through my playlist. Section 98 further strengthens the section 97, where we have right for private defense for the offenses affecting human body and certain offenses affecting the properties like theft, robbery, mischief or criminal trespass, etc. What happens here, if such thing is caused by a person of young age, or the person who is having unsoundness of mind, or the person who is doing that with a misconception, or there is no maturity of understanding, or if he is doing under intoxication, even then we have the right for private defense. That is what discussed under section 98. So it's very clear now, we got the right to private defense to protect ourselves whenever there is offenses affecting human body or property as listed here, that is theft, robbery, mischief and criminal trespass. It may be of ours own, or if it is happening with others, we still have right to private defense, and it is further extended to all those people who are committing those offenses. Maybe he is a young person, or who is having unsoundness of mind, or who has maturity of understanding, or doing the misconception, or intoxicated. We have got right to private defense in all these circumstances. But remember, this is not 100% right. There is an exception, which is a very important aspect we need to know, which is what discussed under section 99, which is a kind of exception to section 97. Now here what happens, an act is done by public servant, then do we have right to private defense? That is a very important aspect, and understand section 99 very clearly. It discusses about public servant who is acting legally, that is very important, who has authority and who is acting with good faith to his office. Now all these three combinations should be there. He should act legally, he should have authority, and he is acting in good faith to his office. In that case, against those acts, we don't have any right to private defense unless and until he or she is going to cause, or there is a clear apprehension of grievous hurt or death. If that is there, we still have right to private defense. Till then, we don't have right to private defense. That is very important. And if he is acting illegally, then that is not covering him also. That is very important aspect. And once we know that it is public servant, we should not do anything to him. That is very important. But that is not 100% excuse. That I am discussing when I am discussing section 101 and 103, which will be my next video. So you have to follow my next video also, because that is a very important video. Now, once we have little time to complain against that particular government officer or the public servant, we have to utilize the same. That is what section 99 says. Now, I have given a brief picture of all these four sections, and from next slide, I will go to explain what exactly this section reads. So in a nutshell, the offenses that you have committed for private defenses are not offenses, and then you can do all those acts for private defense which are affecting the human body or property of yours or others, and then there are defenses available against the actions done by the person of young age, unsoundness of mind, or with a maturity of understanding or misconception, or intoxicated. And finally, there are no private defense available when the act done by the public servant, if he is acting legally with authority and with good faith to his office, unless and until he is going to cause, or there is a clear apprehension of grievous hurt or death. Now let's quickly go through the provisions in the act. I have already explained them, but I'll quickly read through so that you have a clear legal understanding also. Section 96 covers things done in private defense, and it says nothing is an offense which is done in the exercise of the right of private defense. And section 97 says right of private defense of body and property, where it says every person has a right subject to the restrictions contained in section 99, which deals with public servant, to defend his own body and the body of any other person against any offense affecting the human body. There I have referred you chapter 16 of Indian Penal Code. And then the property, whether movable or immovable, of himself or of any other person against any act which is an offense falling under the definition of theft, robbery, mischief or criminal trespass, or which is an attempt to commit theft, robbery, mischief or criminal trespass. Now here I have not told complete chapter 17 because the act has very clearly defined these four acts. That is why we are limiting to there only. Remember, we have case laws also to discuss in the end. Now section 98 says right of private defense against the act of a person of unsound mind. It is not just covering unsound mind, it covers different other people. Let's go through the provision. It says when an act which would otherwise be a certain offense is not that offense by reason of the youth, the want of maturity of understanding, the unsoundness of mind, the intoxication of the person doing that act or by reason of any misconception on the part of that person. Every person has the same right to private defense against that act which he would have if the act were that offense. Now here, whoever is conducting that act, for them also it is not an offense because either he is youth or he is doing without having an understanding or he is having unsoundness of mind, that means he is an insane person, or he is doing under intoxication. Now for him also it may not be an offense, but against him if we are doing or we are very clearly having right of private defense. That is what this section basically says. There are two beautiful illustrations given in the act itself. The first one discusses about whether the person is sane or insane. You have all the right for your private defense, which reads, Z under the influence of madness attempts to kill A. Z is guilty of no offense, but A has the same right of private defense which he would have if Z were sane. Now it doesn't matter whether Z is sane or insane. He is trying to kill A. Now A has all right to utilize his private defense because otherwise he is going to die. That is very important aspect. The second illustration is equally interesting, which says A enters by night a house which he is legally entitled to enter. Now Z in good faith, taking A for housebreaker, attacks A. Here Z by attacking A under this misconception commits no offense, but A has the same right of private defense against Z which he would have if Z were not acting under this misconception. Now what happened here? There are two persons, both of them are legally entitled to enter that particular house, and A one day comes late and Z thinks that it is someone else, and in a good faith of protecting that particular house, he attacks A. Now Z has not committed any offense because first thing, he doesn't know it is that Mr. A. Second thing, he is attacking in the good faith of protecting the house. Now A cannot stop silently because Z is going to attack him, and for protecting himself he has the right to protect or he has the right to private defense. That is all discussed here. Then comes section 99, which is our last part of discussion before we go into case laws. Here it says acts against which there is no right of private defense. We have already got a reference under section 97 also. There are certain acts we don't have right of private defense. What is that? The acts which are done by public servant or someone who is working on the direction of public servant under the good faith of such act with color of his office or working for his office, though it is not strictly justificable by law, we cannot have right of private defense unless and until it is going to cause or there is a clear apprehension of death or grievous hurt. That is about section 99. We have more explanation and illustration for 99 in my next slide. The section very clearly says there is no right of private defense in case in which there is time to have resource to protection of the public authorities. If you have time for taking public authorities protection, then that should be your first option. That is what said under this particular section, and there the extent to which the right may be exercised is also discussed. What is the extent that we can go through? We can go to that extent which is just required to save ourselves. That is very important. Just because in the name of right to private defense, we cannot do harm more than necessarily required. That is very important, which is what discussed here. While reading section 99, one should not get into a misconception that whatever act done by public servant is okay. The private person still have certain defenses available with him, like he can ask like on what authority he is doing that act, and he can maybe ask whether he has certain orders in writing to do that act, or all those stuff can be asked. For example, if someone is coming to arrest you to your home, now you can definitely ask him where is the warrant. These are the things we need to remember. Then comes the case laws. I have 5 case laws here. The first case law is Rasika Bhai Ram Singh Rana versus State of Gujarat. Now, who has the burden to prove that the act is done for private defense? Of course, it is the duty of the accused to prove that he has done that act for his private defense. That is what discussed under this particular case law. Before getting into the second case law, always remember that private defense must be limited to private defense only. We should not exceed our right of private defense to unnecessarily cause excess harm to others. That is very important. Whatever is required to protect ourselves, to that extent we have to act. Now, in the case law of Madan Mohan Pandey versus State of Uttar Pradesh, in judging whether accused has exceeded his right to private defense or not, the court has to take into account the weapons used in that particular defense. That is what discussed under this particular case law. Before getting into third case law, always remember that private defense is not about you fighting yourself. Whenever there are opportunities, you should always approach the authorities only when there is no time. If it is suddenly happens, then only you can act with the right to private defense. It is not a gift you can utilize anytime, even though if you are aware of certain offenses which is going to happen against you, and if you are not taking sufficient care, then that will not protect you. That is what discussed under Lakshman versus State of Orissa, where it was held that the right to private defense can only be provided when the person awaiting it is suddenly confronted with immediate necessity to defend, which is not of his own creation. Further, the necessity should be present, real and apparent. Now, only if it is happened in the present condition, that means suddenly without any anticipation it is happening and it is present in front of us right now, it is really going to happen, or it is apparent that it is going to happen. If all the combination is available, only then we can utilize our right to private defense. Now, if we are already aware that this is going to happen after 3 days, now we have all option to reach the authorities. Instead of reaching them, if we are going and troubling the other person who is planning to attack us, that is not a right way to do it. That is not called as right to private defense. In that case, you should always utilize the support of public authorities only when you cannot reach anyone. The situation is right in front of you. In that case, you can use the right to private defense. In the first case law, that is Ram Singh Rana versus State of Gujarat, I told the burden of proof to prove that there was a requirement of utilization of right to private defense is always on the person who has used it. Saying so, there is a case law, that is Swami Ram versus State of Rajasthan, where it was held that it is not the responsibility of the person who has utilized private defense to prove beyond reasonable manner of doubt. He has to prove it, but it need not to be beyond reasonable manner of doubt. That is what exactly held in the case law of Swami Ram versus State of Rajasthan. I repeatedly told, whenever there is an opportunity, you should utilize the help of the authorities rather using the right of private defense. If the opportunity is pre or post whatsoever, you have to first take the support of the authorities. Only when you don't have that opportunity, that means you are in real situation, there is no other go, then only you can use the right of private defense. Now let's take an example. You have a property. You have all the required legal document about that particular property that it belongs to you. Now someone comes to your property and says that is your property and they acquire it. Now what can you do? You can definitely go to the magistrate, put a complaint and can legally get it back. That is a possibility. But here in the case law, that is Ayodhya Ram versus State, what happened? There was a person by Ayodhya Ram and few people came and took his property. Now Ayodhya Ram got very angry. He, instead of reaching the magistrate and complaining to the magistrate that this belongs to me legally, what he did? He took a gun and shot all the prosecution party members. Now in this case law, it was held that this is not the right of private defense. He had all opportunity to reach the magistrate and he could have taken the property back. Instead of that, he has exceeded the power of private defense, and that is why it is an offense under IPC. That is a very important aspect we need to remember. In the Ayodhya Ram case law, we understood that he has exceeded the power of private defense by killing certain number of people. Now, under any circumstances, can we cause the death of another person to protect ourselves? That is what I am precisely going to discuss in my next video, where we are covering section 100 to 106. Until then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.